Gotcha. Good afternoon, everyone. We're just waiting for our Facebook Live to pick up here, and then we'll get up and going. There we go. Are we good to go there, Caitlin?
Yep, you're good to go.
Okay, perfect. Well, good afternoon. It is afternoon. We're 3 minutes past noon. Paul Markle, Executive Director of the Barrie Chamber of Commerce. I'd like to thank you for joining us for today's session, Entrepreneurs in IP, or Intellectual Property. First, I'd like to begin today's session with a land acknowledgement. In keeping with Indigenous protocol and building respectful relationships between Indigenous and non-Indigenous peoples in Canada, it's customary to acknowledge the traditional territories and ancestral lands of the Indigenous peoples. Barrie Chamber acknowledges the sacred land on which we operate. It's been the site of human activity for 15,000 years. This land is the ancestral land of the Wendat and the Anishinaabeg Nation. The treaties that were signed for this particular parcel of land are the Williams Treaty, Robinson Superior Treaty number 60, Penetanguishene Purchase number 5, and the Nottawasaga Purchase number 18. We're dedicated to honoring Indigenous history and culture. We also recognize the enduring presence of Indigenous peoples on this land, and we're committed to moving forward in the spirit of reconciliation and respect. Miigwech. So today's seminar will touch upon trademark and copyright issues that are relevant to small business in terms of managing your business IP and being alert to situation involving intellectual property that can confront your business. And with us today is Graham Knight. So Graham is a partner with Barriston Law. He practices in the areas of corporate and real estate law. And he offers soundly and timely advice on corporate acquisitions and distributions, corporate financial services, with an emphasis on secured financing and mortgage lending, and incorporations, shareholder and partnership agreements, mergers, leasing, franchising. And his real estate practice addresses both private and corporate conveyances and financing. Graham has practiced trademark and copyright law since 1983. He's also completed his course requirements for a Master's of Law in Intellectual Property and is published in the Intellectual Property Journal. Graham is also a member of the Barrie Chamber of Commerce Board of Directors and has served there and is a great resource for us and a very entertaining gentleman. So I'm really pleased to introduce you, Graham, and to sort of hand things off. So I believe we have a bit of a presentation and then we're going to take some Q&A at the end. So I just ask that everyone please submit your questions into the Q&A at the bottom of your screen, and we'll answer those questions as they pop up once this is complete. Again, if there's anything that's housekeeping related, you can put that into the chat, but I won't be looking at the chat for questions. So with that, Graham, welcome.
Thank you, Paul. Thank you for your kind introduction. The idea today was to be high level, not highfalutin, and not terribly in depth, to get over some concepts you might benefit from knowing, and to maybe point out some traps that I see along the way. Given that we've only got 40 minutes to cover a huge area of law, we'll dispense with the windup and go straight to the pitch. After I started preparing this, I thought, you know what, maybe I'll put 2 or 3 minutes in on patents too. I don't know who's looking in today, but there may be things that just check marks as you go through. So I'm going to race through patents and then spend more time on copyright and trademark. I refer my patents to Toronto. You have to either do patents every day, all day, or you stay away from them because they're a real beast on their own. They apply to inventions that have to be new, useful, and inventive. So you can't patent something that is not useful or somebody else has done already. And they can apply to products, compositions, machines, processes. So for example, a product could be a door lock. The composition could be how the lubricants are mixed to go in the door lock. The machine could be the machine for making door locks, or a process, the method for making them. An improvement might be, I can call on my phone and the lock will open. First to file wins in Canada, and you are given trademark protection as in copyright, as in patent, by the Canadian government, who cannot give you rights that extend further than the borders of Canada. So if you're involved in this sort of stuff, it will apply to trademarks later, but patents for right now, it's wise to look at where are your big markets. You might want a patent in the United States, but maybe you'll pass up on New Guinea because you don't really care given the business you're anticipating doing. Anyway, that's that in a nutshell. Let's move to copyrights. Copyrights relate to, and I'm quoting, an original, literary, dramatic, musical, or artistic work. As we go through both copyright and trademark, think about what you're doing in your own business and where these things might apply, because they can be very valuable to you. Copyright basically is the exclusive right to produce, publish, or perform these works of art or literature or whatever. So in a nutshell, copyright is the right to copy. It exists for your life plus 50 years. After that, it goes in the public domain. We won't get into it today, but there's some very interesting issues coming up on creative works that are actually created by AI and not people. And they're going to say, so who's going to get the copyright in that? To get a copyright, you need a spark of inspiration. If I say, see Paul run under the sun, that is definitely not up at Shakespearean levels with the quality of what the poem is. But if I made it up myself, it's original, and therefore it qualifies for copyright. So it's the creativity, not the quality. You don't have to do any formal filing to get it. There is a copyright database in Ottawa that you can go on and you can file it, which gives you perhaps more proof. People in the past who have sent registered letters to themselves, which they don't open, that include literary works or whatever, to show that it must have been done before this date. You can help yourself, and this is probably very broadly based. You can help yourself by putting that little C in a circle. C 2022. What rights does that give you? Absolutely none, but it enhances your position against someone that infringes your copyright, because you've waved a big flag saying, in case you don't know it, Buster, I am claiming copyright in this. So it's worth doing. You probably have manuals, websites, all sorts of things. We're putting that copyright on. It will assist you, and it takes nothing to do it. Okay, sometimes so many things in law would not be issues if people had just turned their mind to putting things in writing. If you hire someone to do something, when you get the product, you should have in that contract, it is agreed by the parties that the copyright in this whatever is the property of whoever. If I buy a painting, I own the painting, but the artist may keep the copyright, which means I can't take a photograph of the painting and use that photograph in my business or on the front of my Christmas cards or whatever. So this can come up and it can really bite you. In the absence of a specific statement of who owns copyright, the law looks at, is this like an employee? Likely the employer owns the copyright. Is this like an independent contractor? You know nothing about it, and the independent contractor is doing it all for you? Maybe the independent contractor does. But unless you want to make money for lawyers and accountants, it's easy just to write in, we agree the copyright is with whoever. I see that more often than I wish to see it, and it's very time consuming and distracting for people to get involved in these things. There's also, well, I'll call it a scam. There's also a scam going on where copyright is supposed to be for protection of things like images, for example. But what some people are doing is they're putting all sorts of images on the internet. And really, the copyright issue is not to protect their interest. Really, what they're doing is they're putting out bait for infringement. And I've seen a dozen of these where some innocent person takes a picture or takes an image off the internet, puts it on wherever, and then they get a letter. And the letter usually goes, like, if there's a very serious infringement, but we won't sue your brains out if you send us $2,800. And you write back and you say, we don't think so. And then all of a sudden those are, oh, maybe $1,400. So this is the way it goes. And it doesn't matter if one organization in town that we all know, I think they had 3 or 4 hits on their website, and they took it off immediately, and still the other side did not back down. So what they're really playing for is, let's get some nuisance money. So usually we've been settling for $300 or $400, $500 maybe, just to get rid of these people, which is exactly what they want. It's not my business to call the shots, but one wonders sometimes, given what it costs to go to court and how long it takes to go to court, if you just said, go away, even at $2,800, I would think it would be not prudent for the copyright owner to go after it. Anyway, watch for that. If you get one of those letters, watch for it. Another area we can explore here is your websites. And the bad news is, you can talk about copyright all day long, but you probably don't have much in your website. People take a website or a page, and you move this here and you move that there, and you call this something instead of that. And by the time you get to the end, the person who actually made the page knows exactly what they've done, but the two are dissimilar enough to discourage any formal action, because they can say, well, these aren't the same at all. Look at all these differences. So just as we take precedence from each other, I think your websites are going to be vulnerable. Doesn't hurt to put that C in a circle on them, but don't hold your breath about these things protecting you in the long run. Beyond the copyright, we can now move to trademarks. And trademarks are what I do most of, and they've been undergoing huge changes in Canada recently. And they're something that a lot of businesses who have trademarks don't seem to focus on, even though they're valuable. I'm sort of jumping ahead, but if I want to sell you a franchise, if I can say, here's my trademark, you can call yourself McDonald's, that adds a lot of value to that franchise. If you say, well, I think I got the name, I'm not too sure. So if there are areas of your business where you're using logos or words and logos, take a look at getting them trademarked. At any rate, in June of 2019, our whole trademarks regime got materially changed as Canada moved to a European model. And the European model divides up wares or goods and services, ashtrays, ashtray cleaning, into 45 or 46 classes, so that in the future, if you're looking for a trademark on hockey sticks or whatever, you know that you have to look at classification 7 or whatever. So it makes it easier. But it's been a tough change for both practitioners and for the trademark examiners in Ottawa, because all of a sudden we're playing the game with new rules. Previously, trademarks were an indicia of the source or quality of a product, and it applied to goods and services. You had to be active in the marketplace. You can't hoard up trademarks. And it comes from a common sense of fairness. If I'm in the marketplace selling my rocket lawnmowers, I think all businessmen would agree it's not reasonable for somebody to open a stall next to mine and they're selling rocket lawnmowers, because they're stealing my goodwill, they're stealing my reputation. That's what it's all about. They started in the silverware business. Some of you may have seen a little R or some letters stamped on a knife or whatever. Those were the original trademarks. And that told me that whoever R is that was his product. And it was helpful for him because if I saw a fork with R on it, I say, hey, he makes good knives, probably makes good forks. I understand. So that's where these things started. You were distinguishing your goods from other people's and getting protection because of the goodwill that went along with what you're doing. We've now changed the definition to a sign or combination of signs that's used by a person for the purpose of distinguishing their goods. So goods and services are now out as the only two. Why? Because this opens the door to inclusions of all sorts of what we used to call non-traditional trademarks, including scents, tastes, textures, colors, moving images, holograms, all this kind of stuff is coming in, and it will be able to be trademarked. If you're interested, type in the Tarzan trademark, and you will see that some guy that knows music has actually scripted all that yodeling that he does on what notes and whatever. So they're protecting. What I'm interested to find out is, I don't know this thing about scents, whether you go to Ottawa and sniff in a jar or something. I don't know how you do that when it's a sense of smell, not of sight that we've been going with. At any rate, they have to have some form of distinctiveness. And when we get to distinctiveness, what we're talking about is there somehow unique or original? And one of the things that quite often will come up is that people will make their trademarks too descriptive. I build cars, so I decide to trademark fast car. That just tells you my car is fast, but I'm not allowed to trademark that because then nobody else could say I have a fast car. So a very distinctive trademark is a very powerful one. Kleenex, for example, what's that got to do with facial tissues? Alligator for jumper cables. It's got nothing to do with jumper cables. We all understand those little clasps at the end. That's the connection, but we all understand that. So if you're thinking of bringing out a product, if you call it a zebra or whatever you want to call it, if it has nothing to do with the product, you're much more likely to get it because it's not descriptive, and it's very unlikely if you bring out zebra for snow shovels. It's very unlikely somebody else has done that. So that's just a rule of thumb. And the more distinctive the more descriptive you get, the weaker it gets, and the less likely you are to get it. You have trademarks whether you do anything at law or not. If I've been running Graham's Rocket Lawnmowers for 20 years, I will have established a common law trademark that gives me the right to use that name because I've been active. If somebody else comes out with a rocket, then I have to show where I sell my goods, what are my channels of trade, who are my clients, is it likely the other guy would have had my name come to his attention? Have I received letters that should have gone to him because there's confusion? All this. If you have a registered trademark, you put it on the table and you say, talk to me, here's my trademark. Trademarks are good for 10 years, by the way. There's a process which has slowed down now to a point of being commercially embarrassing. I have 2019 trademark applications where I haven't had a response from a trademark examiner in Ottawa yet. So basically the government is operating on, well, we'll tell you, 3 years later, whether you are allowed to use this business name you're putting time and effort and money and goodwill into. Hopefully that'll catch up. I think that's probably a function of changing to the European model and people's growing awareness that these things are worth having. How do you do it? First of all, I suggest to people there's a thing called the Trademark Database. And that's CIPO's, Canadian Intellectual Property Office. If you go in there and type in the name you're after, rocket, it'll come up with all the rockets that are either pending or have been given trademark rights. It's good because it will tell you when you're dead in the water. Joe Blow down the street, registered rocket as a trademark for lawnmowers. Forget it, go and do something else. But it's also dangerous because there may be trademarks that are close enough to cause you trouble that you don't see. You're only getting direct hits. If you don't get a direct hit, then there's something called the preliminary trademark registrability search. And that's like searching a title to your house when you buy it, except it's searching a title to a trademark. So they check all the rockets and all the lawnmowers and see if there's anything out there that is going to be a problem. When you file your trademark application, which is the next step, it starts off by saying the applicant is satisfied it's available for use in Canada. That's because you've done your search. Some people will take a risk. The preliminary trademark search is about $700. So some people will take a risk and just send it in without doing the search. I understand why you want to save money, but I find it risky. If you get no pushback from the examiners, it goes out to advertising and it's registered, it's good for 10 years and can be renewed before it runs out. I like old-fashioned trademarks because they're not as susceptible to changes. Like you might look at a house or an ad and say, boy, that was done in the 60s. Whereas if you get something that looks like it was in the 30s, it's not likely to go out of style. Whereas something that's just too current and too hot might not look that good in 5 or 10 years. You can have an image or a word, we've covered that. You can claim color or not. I don't know this, but I suspect that our eye is trained to pick up the red in the Coca-Cola cans. So it's very important for them to not have Coca-Cola like people or drinks with that red color. But if you claim no colors, then you essentially got all colors. So most people claim no colors. You can use a French equivalent if you want to. The cost, by the time you're finished, it's usually about $3,500, $4,000, of which there's $700 out of pocket for the search. The government charges, it has a new regime of charging, which I think is $340 for the first NIS convention classification you choose. So the more classifications you claim, the more your trademark is going to cost you. And then the other one, as far as the legal fees, is something like going to court. Like you could go through and it could be a yawner, or you could go through and have to duke it out all the way through. So that's hard to predict. But while you're in the process, you're going to know. If Molson sends something saying hell's going to freeze over before we're going to let you have this trademark, then you know that you're either going to get into very deep water or you're just going to retreat and try another trademark. So you can't get surprised as so to speak. There's other issues here that on a practical basis and that can trip people up. And they include things like, I don't think trademarks are that relevant to my business. Well, your business is goodwill and has goodwill, and hopefully that goodwill is increasing day by day. So every day that my rocket lawnmower truck goes by your house, I'm building goodwill in that. I have advertisements. People know when they go in if they like these machines, if they don't. You're building. If I get a letter saying, Graham, cease and desist, here's my trademark from 2002. If I've got to take all this stuff down and start from scratch again, it is at least very time consuming and dislocating. By the way, if you get those kind of letters, usually you can push for 6 months to change, to say like, I got to rejig everything here. I'll agree to back off, but give me 6 months. And the bottom line is it's reasonable. And the other bottom line is if they don't let you do it, by the time they get to court to fight about it, the 6 months is going to be up anyway. So they pretty much have to give that to you. So IP issues are relevant to you day to day. And as I said, we've already touched on it, but look at the things you have in your business where you might have opportunities to do those trademarks. It's also relevant to the extent that you can license these things. So I can license somebody to sell lawnmowers in Saskatchewan. So I'm getting a cut of what's going on. They're doing it, but I'm able to do that on the back of my trademark, so to speak. Another one that I really understand and have sympathy for is, look, IP protection costs too much. You just told me like $4,000. I'm starting a business, I'm starting a product. Give me a break. I need that money for other things first. I hear you. It makes sense to have it, but I'm sorry, it's just not a priority for me financially right now. As we've noticed, as we've discussed in the cease and desist regime, you can spend way more than what it costs for a trademark very quickly if the name you're using runs into trouble really quickly. So it's, maybe I could say more accurately, it costs too much not to do it. Having said that, I get economics and all that, but take it seriously because you have things that are valuable. Another one that I get, and it probably ties in with more startups and limited budgets, is, hey, look, I get it. We should have a trademark, but I don't know, this thing may fall flat in its face. So why don't I go to the market, run this thing for a year or so? If it looks like it's taking off, then it will justify the costs of doing it. If it's going to fall flat in its face, why would I bother spending the money? Well, we circle around again and come back to how much time, effort, and money are you putting into marketing it to see it's successful? It's not great to go to somebody you deal with and say, I was rocket last week, but this week I'm torpedo. Like it doesn't make sense from a business point of view from your goodwill. Another one, again, more often than not with startups, is just waltzing into the market without any homework done at all. We've talked about the availability of going on the Canadian Intellectual Property Database to take a look around. We've talked about, you can also do things like telephone book searches. One of the very, very inexpensive but misunderstood ways of getting something is businesses can carry on under a name other than their own. So Markle Enterprises can register Rocket Lawnmowers as one of the names under which they do business. And it's good for 5 years. It's under the Business Names Act, and it's available in Ontario. Now, the mistake people make is, number one, they don't search to see what styles are registered before they do it. And the second mistake is that there is no proprietary interest in the business name registration at all. All it does is link a style with who the true owner is. So if I get run over by a truck that says coconut packaging on the outside, I can look at coconut packaging and see that Joe Blow is the actual owner of that. Okay, having said that there's no proprietary interest. The other side of the coin is, if somebody registers that, it will raise an inference they're doing business in the marketplace. And if you have registered it for 5 years and you renew it twice, now we're up to 15 years, there gets to be a stronger case of, you know what, I think this guy has got some rights in the marketplace, because that's fairly convincing that he's had this style registered for that period of time. So it's the inference you're taking, other than a trademark gives you legal rights. A business name registration gives you no legal rights, but it may raise an inference and it may be helpful. And I can't remember what it costs, but I think it's in the range of $60 or something. So when all's said and done, that one doesn't hurt, but be careful to be able to measure the protection you're actually getting. Last, I just take a little bit of a run here at confidentiality agreements. If you have trademarks you're carrying on or whatever, you may want to mention stuff in there to make sure everybody knows, like the copyright that we discussed, everybody knows whose trademark is this? Like, is it Graham's or is it Graham's company's trademark? What if Graham leaves his company? Who gets the trademark? And I don't want to get too far afield. Confidentiality agreements also cover things like trade secrets, and trade secrets are another area of intellectual property. So these probably are of pretty wide use, no matter what business you're in, if you're watching this. And they will set out, as is the monotonous drone from lawyers, get it in writing. They will set out who is able to do what. And if I leave, I can't disclose this stuff and it's in there. Remember that when you hire somebody, you can say, Bill, I'm going to hire you for X dollars a week, and here's the terms and conditions. Bill agrees, they got a deal. If you come to Bill 3 weeks later and say, here's a confidentiality agreement, sign it, he can say at contract law, what's in it for me? I'm extending consideration to you, and I'm getting absolutely nothing for signing this. I'm not going to do it. And he's right. But take a look at what's confidential in your business. Try to get these things in for the trade secret IP stuff. And when it becomes raise time next year, or if he's going to be given an extra week's holidays, or something flows to Bill, then you can say, I'm happy to give you a raise of this and an extra week's holidays, in return for which I would like this confidentiality agreement signed. So the bottom line of all this stuff is, when a guy or a woman starts at your business, get that confidentiality agreement signed as part of the negotiations that lead to employer-employee relationships, or however you want to define them. The other employees, make a note when it comes time for assessing performance, compensation, stuff like that. Get one of these things in there. You're not home and dried off if you have a confidentiality agreement, but you're sure in a whole lot better of a situation than if you don't have one. So you probably heard enough from me. I don't know whether there's any people who have questions or want to pursue this further, but if I can answer it, I'm happy to try if you have any questions.
Yeah, well, that was that was very interesting, Graham. I mean, wow. I did in my former life have a little bit of experience kind of chasing down information. I was a private investigator for a while, and occasionally we would have people that would have infringements, and you would have to do some background research to dig up, whether somebody was using something, or maybe it was a product, and maybe it was the result of a non-compete or a confidentiality thing, and you were trying to find out whether or not they'd actually violated the terms of those agreements. So, touched on it, but never really had a great understanding of it. So this was really kind of interesting. Especially the last section you just covered with regards to employment agreements. Didn't really have a fully understanding of why it would have a non-compete or a confidentiality agreement in some of those for any basic job. But I mean, it totally makes sense that anything that may come across somebody's bow needs to be protected, and it's much easier to have that stuff up front. So your initial comment about document, I mean, have things written down, I think is critical in all business, and I think it's a fatal mistake. So busy doing things that that stuff falls off the side. So great information there. We have a couple of questions in here with regards to. One of them is with regards to international intellectual property law and how to find out more information about that. And the second question is about further sources of information on copyright. So the natural would be, well, contact Graham and he'll help you out with anything you need. But where do people research this stuff as they begin to build their businesses out and to make sure that they're going about it the right way?
couple of things. Number one is I've used the same trademark agent since 1983, and his law firm, he's a searcher of trademarks, not an intellectual property lawyer, but his law firm does nothing except IP. So what I do for international stuff is, and I did last week, is somebody wants a trademark in the States. I called him and say, like, who do you guys deal with? I'm from Barrie. I can do trademarks here, but I don't know anything about Hawaii or whatever. So I would go to someone that's specialized and sophisticated in Canada and say, you have links with these people. Tell me someone who you trust and thinks are good. So that's number one. Number two, what was the second one, Paul?
It was more around how do you find more sources of information on copyright?
Well, if you go on the internet, you will see, I mean, you can sift through it, but you will see, first of all, the Copyright Act comes up. That's pretty dry. But there's also, there'll be commentaries on copyright on the internet that are pretty good. And
okay.
You can tell pretty quickly whether, is this an area that I'm interested in, does this address my concerns, or is this something else?
Right.
But that's
and that makes sense. I mean, one of your comments in here was, the cost of it, can be fairly expensive, but, relative to what the impact is if you run into a problem, I would say it's wise if you're getting into a business where you're building out a product or developing a service or something where they've got proprietary information or products, that you build that into your startup costs. And I think that may be something that is missed a lot of the time as people are beginning to build out their companies. Suffice it to say, when you're looking at international, I mean, don't forget that, the States is international, and you should really be thinking about where your products may wind up or services at some point, and whether you need to search, for any kind of copyright infringement in those particular areas. Is there like a central, any kind of a central database with respect to that, or is that basically what the government does? Do they look in other areas, or are they strictly looking in Canada?
No, you can register. All sovereign states have their sovereignty end at their borders.
Okay.
So no state can make, US tries it sometimes, but no state is supposed to be making laws that apply to other people's jurisdictions. So Canada does that. I think you can register, I think it's called the Madrid Protocol, but there is a place in the EU where you can register an EU trademark, which makes a whole lot of sense because it saves you going for each country in the EU. Right.
Okay.
And US is the other one, because for most people, if you've got Europe, United States, and Canada, you're into diminishing returns for the, maybe that's unfair, but you got the big ones if you got those.
You got those ones taken care of.
Yep.
So, I mean, this issue with China and their ability to reproduce things at a remarkable pace and generally good quality as well. So this is that, one of those situations as well where they make a small change to the way that something is produced, and then it comes back. I mean, how often do they get taken down based on copyright or trademark?
I guess the honest answer, Paul, is I don't know, but from what I've seen is that I think when they were starting off, they were way behind the eight ball. So they would just blatantly steal and say, so what are you gonna do about it?
Right.
Now their products are becoming better and more sophisticated. They're going, hey, wait a minute, people are stealing ours. So they are now exhibiting a different attitude towards trademarks because now they got something to lose.
Right.
Take that with a grain of salt. I don't get involved in that, but that's my perception.
Okay, so it starts to level the field a little bit.
Yep.
It's not a bad thing. So there's a question in here. Can you speak how on the term fair dealing and how it applies to or relates to copyright?
Okay. You are able, if somebody has rights, you have to respect those rights. But you are able to address some of the rights of other people if you do it fairly. Okay. My Nivea cream bottle is 3 ounces bigger than Nivea's. They have a right to that name and whatever. That's maybe a very bad example, but what I'm trying to come at is that I'm not abusing their rights in any manner by what I'm doing.
Mhm.
Okay, fair deal. You also get things like parody and we were just kidding and it's humorous and all of which are a bit of a minefield. You better be careful you go through there. But that is my understanding, is the fair dealing is something that does not infringe, respects rights, but deals with them in such a way that, like goodwill, the public will say, you know, that's fair. There's nothing wrong going on there.
Okay, okay,
I don't
good.
know whether that answers it fully.
I think so, yeah. I seem to be able to understand that. So if I can, I'm pretty sure everyone else does. And the difference between, and again, the difference between copyright and intellectual property.
Copyright is one division of intellectual property. We've touched on trade secrets, patents, trademarks, copyright. There's industrial designs. There's other things. So it's like it's one of the positions on a hockey team.
Right, gotcha.
IP is the hockey team. Copyright is the left winger.
Right, gotcha. Okay, that makes total sense. The other piece that you talked about with the business registrations was interesting as well, and I think you know, a lot of times that again, when I was working and trying to search for companies or people, it becomes a bit of a thing where you sort of hide behind that operating name it's again an important thing, I think, for businesses as starting up to make sure they pay attention to. You know, you have an Ontario numbered company and then you have operating as, but you know, you can make a number of different moves as you try to shift your products underneath that one shell, or services by using some different you know, business operating names. You know, can you maybe expand on that particular portion a little bit more?
Yeah, one of the things that I perhaps should have covered is that under the Business Names Act, you can operate on a name that is not your formal legal name, but on all contracts, bills of exchange, orders for services, whatever, you must show that Rocket Lawnmower is a division of 1, 2, 3, 4, 5, 6. So
Right.
if you don't, so you have to show your actual legal name. It might be accurate just on any document that could be part of a lawsuit, so people know who they're dealing with.
Okay. Okay, that makes sense. Yeah. So that you don't
By
have
the
to,
way, if you don't, under the Business Names Act, I think the Business Names Act says I cannot defend an action or I cannot bring an action if I haven't done that.
really,
It has a bite to it. I mean, people rush out and register right away, but
of course, yeah.
there is a reason to do it.
Well, I don't know why you would for $60. I mean, it doesn't take anything to do the registration. I think it's just, I think people probably just do it because they don't understand.
Mhm.
You know, quite honestly, when I started my corp, you know, there was, it was worse than buying a house, the number of things you had to sign. And there was a lot of stuff there that you didn't really understand what you were getting yourself into. But I think, you know, engaging with, you know, with a law firm, a reputable law firm, I've dealt with Barriston and with my business as well, where they take the time to explain things and really go through it so that you understand. They're not going to tell you one way or the other where you need to go. They're just going to give you the advice that allows you to make the best decision. And I think that's an important nuance in there. I don't have any other questions on the. Oh, actually, no, one just popped up. When is the best time to protect my intellectual property? As soon as possible, I would think. Yeah, don't wait.
Yeah, that's the best time. I also didn't mention, if you are starting a business where there either franchising is in your mind or it's a possibility, then the urgency of getting on that earlier is even higher, because you ain't going anywhere if you can't protect your name.
Right. you're going to have, again, people coming up behind you, maybe thinking your concept and making it their own. And if you haven't protected it, you're kind of out to lunch.
Mhm.
It's kind of the McDonald's story when you really get down to it. I mean, they gave up that name too quickly. And as a result, kind of missed the boat on a lot of it when it really kind of blew up. That whole story is kind of interesting. Again, my McDonald's background was interesting watching that and how those franchising models moved. But definitely a part of law that I don't think a lot of people spend a lot of time trying to understand. So I appreciate you coming today and giving us an opportunity to kind of learn a bit more about it. Before we go, is there anything else that you wanted to add to that we didn't cover off?
So I think I've said my piece. I don't know if anybody watching wants to add anything more, but.
Yeah, we've had, I don't have any other questions that have sort of popped up. Oh, wait a minute. Can you sell an idea to a company without a patent?
Yes, you can. These are, okay. I mentioned I don't practice the law, but when we studied it, you got to get confidentiality agreements. Thank you, sir. I like your idea. Who was that guy? I don't remember him coming in last week. So we run away with the patent. And the how robust that confidentiality agreement is, it is probably tied into the ethics of the company you're dealing with.
Right.
If they're sharks, they'll say yeah, and steal it. But you should have something documented. I touched upon earlier the sort of easy, I put it in an envelope, send it registered mail to myself. I don't open it. I got the date, February 23, stamped on it, or 24. And then if something comes up later and it was stolen from you, you can say, well, here, take a look at this. Here's the plans for it. That letter was sent to me 2 years ago. I haven't opened it. So how can these guys come out a year later and deny that I ever talked to them about the plan? So as I say, these aren't, you won't find that in any legislation.
No.
Prima facie, if the thing hasn't been opened and what's in there is what's in contention, like what other inference are you going to draw? It was in existence at or before that date.
Very interesting. And I would imagine a little less expensive a registered mail versus while you're waiting on that patent. Yeah, that's super smart. Good advice. Good advice for sure. Well, Graham, thank you for your time. I appreciate that. It was like, again, a very interesting topic. I wish you'd come back at a future date and maybe expand on a couple more that maybe maybe some of the other things that you do in your practice, because I'm sure that our listeners would love to understand that a bit better. And these things are all very, very helpful in both starting your business, but continuing on and as you begin to scale as well. So
thanks for having me on, Paul. I love this area of law, so it's just fun for me to talk about it.
Well, it's your passion for it is obvious, and again, always a great sense of humor in everything we do. So again, I appreciate your time. With everyone else today, I'd like to thank you for coming and just remind you that the Barrie Chamber has got a number of different initiatives on. We do have rapid screens back in the chamber now. We have a new ordering system where you can place your orders for rapid screens. And just so you know, you don't get a confirmation email back with that. We're populating a spreadsheet as soon as you fill out the form. So we've got your order as soon as you hit send. And it simplifies things. It allows us to make sure that we don't have product flowing out into other communities. They have their support, so we're going to protect ours. We've also got a couple other activities coming up. Chamber Chat Networking at noon on March 2nd, which is next week. And then we also have our Women in Business Awards. We've got a date set in April, at the end of April. For that, we're still monkeying around with that. There may be a shift, so I won't give you the date yet. We just want to make sure that everything's firmed up. But the judging is done. We have, for the most part, all of that is complete, and we will be making announcements on finalists very, very soon. We don't want to do it too far out for obvious reasons. We want to make sure that we do it right and give everybody their due. So stay tuned for that. And again, we are here to serve and to help you in any way we can. So please reach out if there's anything that you feel that we can do on your behalf. And with that, Graham, have a nice afternoon. I'm sure you're going off for lunch now.
Thanks.
You
Have a
guys-
good day.
Bye-bye.